આપી દેજો બાકી સાક્ષી નથી બોલાય. આરોપીને જવા દેજો, તારીખ મોડે જોઈ લેજો, મુદ્દામાલ માટે કંઈક બાકી છે. ક્યાંથી વરણ ચાલુ? એ મુજબ વકીલ કોણ છે? અચ્છા, નથી આવતા આરોપી? નંબર 1 એ નથી, 1 નંબર નથી. 1 અને 2 આ બે ના ઓર્ડર થઈ જાય. બીજો કઈ યુટીપી લોકેશન બની? એફએસ કેવું છે? એફએસ 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 આપી બે નંબર એફએસ થઈ ગયો. તારીખ નાખી દેવાની. હવે તો બાકીના તો 12 છે ને. બોલો તો આગળ ત્રણેય આગળ બોલો. ત્રણેય આગળ બોલો. ગુલગવાસ ખાન ને સમીર અલી ક્યાં છે? ગુલ ગવાસ ખાન અને સમીર અલી ક્યાં છે? ખબર નથી. તમને ખબર? કેટલે દૂર? તમે ક્યાં રહ્યો છો? અને એ ક્યાં રહ્યો? પેલા કેમ ભેગા થતા હતા? ભાણિયું છે તો પછી એમ કેમ બધું દૂર રહે છે? દૂર રહે છે એટલે કે બાર વિદેશમાં રહે છે? ભાણિયું થાય છે એમ પાછું? આ ક્યાં છે બે જણા? નથી હાજર કરાવો ને, કેમ નથી કરાવતો? તમારો કેસ ખેંચાય છે? દલીલ ઉપર તો છે હવે. આમ ક્યાં રહે છે એ ખબર છે? કઈ નથી. એને લીધે તમારો કેસ લાંબો થાય છે. અને આ ગુલ ગવાસ ખાન એને એ શું થાય તમારે? ઓળખતા જ નથી. એના સમીર અલી ભાઈબંધ હતા. એ ક્યાં રહ્યો છે આવડો ગુલ ગવાસ? અચ્છા. તારીખ આપી. તમે ઓબ્લેસ કરો એના કરતા ગુલ ગવાસ ખાન ને લઈ આવો અહીંયા, તો હું તમને ઓબ્લેસ કહીશ. ભાગેડું થયું, ભાગી ગયો છે, એમાં ઓબ્લેસ શું તારીખ? નંબર સ્ટે છે, સ્ટે છે, સ્ટે થયેલ. હા, ક્યારે દાખલ કરી ક્રોસિંગ? દાખલ કરી એને 16 મુદત છે, ચાર્જ ફ્રેમ ઉપર પડી છે. હું સ્ટે નહીં હોય તો હું તો ચાર્જ ફ્રેમ કરી દઈશ. નેક્સ્ટ તો પછી આવશે, પેલા આજની તો લ્યો મુદત. અને ક્રોસિંગ કોને કરી છે? પાંચે પાંચે ક્રોસિંગ કરી. 28/2 ની તારીખ પડી છે હવે તમારે. એટલું બધું રાહ ન જો ભાઈ, 3 મહિનાની તારીખ. બીજો કયો કેસ આજે જ છે? કયો નંબર છે? એ ક્રોસ કેસ છે? ક્રોસ કેસ ના હોય એમાં. તો ભાઈ ભેગો કેમ નથી કરાવતા ક્રોસ કેસ હોય તો? બોલો, હું તો ચાર્જ ફ્રેમ કરી નાખી નહીં તો. પણ ચાર્જ ફ્રેમ થાય હાઈકોર્ટ તો કોર્સ કરે છે એમાં હું. તો તમારા કેસમાં મેરિટ હશે તો સમાધાન મૂક્યા જ બેમાં. તો બી છેક 7 બીજા મહિનાની તારીખ આપી. તો હું શું કર્યું? ચાલો આમાં સ્ટેટસ રજૂ કરો પેલા. 300 યસ પીપી આજ મારે જોઈ લેવું ને એ મારે નથી સાંભળવું જોઈ લેવું ડી નથી એમાં 21 માં ડી તમે બોટ તો જોતા જાઓ બે આમાં બાકી રાખજો કારણ કે હું સવારે આ કામ કરવાનું ચાલુ કરી દઉં ડી ના કેસો છે ને પીપી ને બોર્ડ
11/22
બીજો ફિરોજ કે
કોણે આરોપી હશે
હાજર
હા કોણે આરોપી 4 પંચોને કરેલા છે
નથી આવ્યો રાજુ
19/22 ઉદયવી પ્રજાપતિ ઈ પ્રજાપતિ ફરિયાદી અને સારે ખબર છે 17 જાન્યુઆરી
સાક્ષી રાજોડો
286/22 મોહસિનભાઈ
બાકી રહો
306/22 મોહમ્મદ અંસારી
યસ
ના
રાજોડો
6/23 રજનીકાંત
તારીખ આપી જાન્યુઆરી
8/23 એક બે ને 4 નંબર 1
એનબીડબ્લ્યુ કોનું છે
બોલો સની કુમાર લાલજીભાઈ એને ત્રણ બધાનો વોરંટ ચાલુ છે
કોણ છે એમના વકીલ તેની અરજી
છે બે મુદત નંબર 1 છે એ મુદત
બરોબર 500 બંને
બે
બધા આવી ગયા હવે આમાં
એકની એક્શન
પણ બધા હાજર છે ને હવે
હા
ઓકે
એમાં ડી રજૂ થઈ ગયું છે 4 પર
પેલા કરજો પછી તારીખ આપજો
134/23 દીપકભાઈ ડીસીમાં હાજર
આવે લઈ લો
1/19 એમાં બધાને એક જ
છે ડિસ્ચાર્જ ની અરજી છે ને આઈડી પણ બધાની છે શું ગ્રાઉન્ડ છે એમાં બાકી રાખવું છે.
એના એક 7/23.
બધા તરફે તમે આવો છો એમાં અત્યારે? નથી, આમાં આમાં કરીશ. અચ્છા, કઈ તો આવતી તમે એપિયર થવાના છો ને, તો અત્યારે એપ્લિકેશન આપ્યું ને તમે હાજર થવાના છો. આપો મુદત માટે અરજી તો આપો. હા, કે હાજર થવાના છીએ એમાં.
22. છે.
સેન્ટ્રલ જેલ. ચાલો આમાં એનઆઈ માં 22/12.
હજી રિપોર્ટ કોઈ આવ્યો
શેમાં?
સિરિયલ નંબર 4.
એ બપોર એ સેવા ચાલો સાક્ષી લઈ જાઓ. તો પેલી એક ઓર્ડર ઉપર છે. હવે 74-23 પકાર કરાવી દો છે એમના વકીલ બંને. એનઆઈએની મેટર એમાં છે. એના કોણ એમાં હાજર થાય છે? એનું આવી ગયું છે પેલું? ના ના, એમનો રિપ્લાય આવી ગયો છે. આજે આપવાનું છે ને, એ આવી જાય પછી સાંભળશું આપણે. Run the matter. Okay, no issue. But let first collect that reply. Yes. Yes. It gives a first impression to anybody else. The picture of this man and what the education industry is that what that I have received. Consideration of the incentive for the consideration to send that those mails or get the details. Yes. What they are also saying that this required raw and complete raw and investment. Now the investigation. After conclusion of the investigation, there is no indication not that I have received a single penny, either from ProActives or from any other organization or from any opposition. There is no evidence that I have received it. So no indication is that I have received it. This attention of the past that the whole investigation not find any evidence. I have received it. Not as far as other dates are concerned, I was a part of it. I was just because the entire set of we are not there. But they will provide for helpful. The prima facie for this juncture, they have not produced complete data. This all after electricity. Along with the target, I think for so at this time, they can provide, they have a right to provide during that time. It's not often. But at this juncture, for I the question to myself, whether the evidence, electronic evidence, they are relying on can be used without the certificate of 65 of evidence that must be declared. That is also one of the countries that I think so these are the education channels. So I am not going to consider any of your argument which would be considered at the time of trial, so far as it touches the evidentiary value. Whether 65B right now, whether it can be applicable, so we will not go into that area. No, you may continue, but you can during the trial. At present, some point of this judgment, keep reviewing the order path that will affect the form of direct website, the judgment on the basis of which this FIR is possible. Those observations were unpassed. The site for direct the password of the improve the investigation of the case of that that is what the effects for the direct vital documents, they are still the same. The different when it comes out, they are saying that it is not available in the register of that tax. They are saying that so that you don't want to go leadership. I don't think I can start to think about what I one. Judgment of judgment what is part in the assembly private Jafia law. Diary number 34207. Now, what do you want to point out from this? Yes. The order is a parcel of that. Yes, yes, it is here. I have. Now, what you? I just want to draw the attention of paragraph 10. N. Yes. Now, why you want to read this paragraph? He directs government of Gujarat to take over all the that is one thing. The Supreme Court was directing to government of Gujarat to forward all the vital documents, vital work of before the. Now, these documents for our concern, the documents which include not the register of tax, all the documents where they are raised. So far as vital is concerned, yes, it does not form the part of the direction. This is something like committee has also sought direction, yes, to hand over all vital documents. Now, what is directed is to hand over all the documents. All the documents which have been requisitioned by the seat. By the seat, without any further delay, the seat would try to complete the inquiry in the matter explicitly. So the documents not in my humble submission. This is the vital documents or the required documents which they are on page number 199. But if that was not supplied, then you should have tell to the apex court. Now that matter has come to an end. Exactly, Lord. I'm grateful to my Lord. That is what I'm submitting. Yes. Once, my Lord, this entire issue is come to an end. Where, my Lord, the final report which is running in the 26,000 pages, where, my Lord, the report of Nanavati and Mehta Commission was submitted, where, my Lord, the investigation of SIT was submitted, where the same allegations they were against same allegations. It was submitted before the court number 11. Court number 11 has accepted them. Now, my Lord, I put a question to myself that if the grievance is that I forged something just to implicate some persons, first, my Lord, Nanavati and Mehta Commission could have filed a complaint if I'm giving a false deposition before the commission. They can file a complaint. 340 will play. Same was submitted by the SIT. SIT has not filed the complaint. Same was submitted before the court number 11. The court number 11 has not filed it. The matter ends there. That is what I am submitting. No. I am telling that the matter before the apex court has come to an end. If you were not provided the document. I'm not raising grievance on that. Okay. I understand my Lord's query that if I have a grievance that they have not complied with the order, then I would have told. No, Lord, my grievance is not that whether they have complied or not. My grievance is that, Lord, that the number of the time when the apex court has said that documents are required to be filed. They have not filed, Lord. It is well known to them. Okay, I take your arguments at no point of time there was any allegation against you of having committed forgery or okay, so that
I'd like to take my law. That's what the only the another submission is that what, as my lord is saying that my grant that I will not take it into the B.
no, we are not going to go through all
Yes,
this.
but my another submission is that SID, I will, I understand. Only my submission to this honorable court might not kindly turn to the page number 202, where the Supreme Court has says that the statement which have been recorded in the Zakia Zafri case may not be used other. Now, if my lord may kindly see 202.
202.
202. It is a further clarified that the statements recorded in inquiry shall only be used in the proceedings related to the complaint dated after
Wait a minute.
202 page number below. Fourth paragraph, that is in a bold. Starts from not since the statement recorded contains signature. Am I talking about 202 section? For the 202 is the page upper top for us, right?
Yes, it is 202.
Now, if my lord can see in the bold letter below, there are two paragraphs. First, since the statements.
Yes.
Since the statements recorded contain signature, it is clarified that if the signed statements are applied, the same shall be treated as the statements made under 161 of Code of Criminal Procedure. It is further clarified that the statements recorded in the inquiry shall only be used with the proceedings related to the complaint dated June 8, 2006, filed by the appellant. It shall not be used for any other purpose or in connection with any other case. He also clarified that the present order is confined to the fact and circumstances of the complaint dated Art shall be and shall not be treated as a precedent in any case. They found, Lord the Honorable Apex Court, that these are the statements which have been recorded during the inquiry for the purpose of this case, which ends in Lord Court number 11 after submission of final decision. They cannot use except.
Yes.
I'm not doing the
Yes.
I'm not doing this for proceedings. The Supreme Court has appointed amicus curiae. There are 2 or 3 amicus curiae was appointed. They have withdrawn themselves. But one amicus curiae was learned Advocate Raju Ram. They have submitted a report on the basis of allegations, findings of the scene, and his own observation. Now, that report, the FIR is on the basis of this order passed by the Honorable Apex Court. The same matter contains the report of amicus curiae. Is reproduced out of page number 208. I'm sorry, 308 of the judgment. It is also in a bold note.
Judgment.
I'm sorry, it is not. P17.
For my paging, it ends at 307, the judgment. Can you tell me the
not supplied in this. What confusion I have. This is not the parcel of this package, but I will give the judgment. It is a judgment.
So, opinion of
Maybe Xerox, not that issue.
According to the old, required of marriage, the order according to
Report of MIS. Maybe they cannot deny. I will supply this.
part of the charge.
No, this is a part of the judgment. If it is a part of the judgment, it must be a part of the judgment. They can produce the judgment along. I just giving not it is annexure 1 and 162.
yes, I have it. Annexure 1 it is 162, but
Yes,
the judgment ends at para 92.
these ones. Now, opinion
This
of.
is opinion of-
Yes.
Yes.
Because that is what I'm asking.
H. What is- It is here.
I have been, my was a charge sheet. Lord, my lord is having the copy.
Yes.
My lord's hand. This is the MIS student report, where the allegation is raised with the this case is that what I paid to prove my presence over the house of CM at that time. And that is the statement I made. I say that, and that is why I have been charged. Now, if my lord may kindly appreciate, when my lord the allegation, same allegation which is raised by the state is a part of that MIS report, findings are there. Now, observation, if my lord may kindly see the observation number. Three,
Yes.
it may not be correct. Am I with my lord?
Yes.
It may not be correct to rule out the presence of Sanjeev Bhatt person, since additional intelligence writer was not available. There is no reason for him to make a wrong statement. He was willing to make a statement if he was protected from the legal process and of the disclosing what transpired in the meeting. So this possibility cannot be ruled out. That is the observation of the MIS. This way. Not my insufficient to this is that. Still, it is under the gray area law, whether I was present or not present. Allegations is given that I was not present, but this observation of MIS clearly suggests that this possibility of my presence cannot be ruled out. Whether I may be right or wrong, but that is my humble submission. It is the duty of the prosecution to prove that I was not. Now, is all our suspicions regarding this. This investigation is carried out against. Now, Lord, I would like to take my lord the charge sheet. Where, Lord, for the charges I have been shown as an accused. The charges which is, Lord, cited against him that was 468. Now, I would like to take my lord on the definition of this 468, Lord. The IPC says 468 forgery for the purpose of cheating. Whoever commits forgery intending that the document or electronic record forged shall be used for the purpose of cheating shall be punished with the imprisonment of either 7 years and shall be fined. So, but not with it. Now, Lord, just to understand the forgery law, the definition is that forgery for the purpose of cheating. Lord, I would like to take my lord on the section 463, where Lord the IPC has given the definition of forgery. 463. That is forgery, the definition of forgery. Whoever makes any false document or false electronic record or part of a documentary or electronic record with intent to cause damage or injury to the public or any person or to support any claim title to cause any person to part with the property or to enter into any express or implied contract or with intent to commit a fraud, that fraud may be commits forgery. Now, Lord, here the reference is given, it's not in forgery. Whoever makes any false document, makes false document, that fall under the forgery. If he fall under the forgery law, then there is a 460. Now, Lord, the definition of false document, making a false document is also given. That is 460. A person is said to make a false document or false electronic record first to dishonestly or fraudulent. These two ingredients must be required. In IPC Milord 464, dishonestly or fraudulently. First, make sign, seals, execute a document, part of document, makes or transmit an electronic record, part of an electronic record, so and so, so and so. For the purpose, now Milord, here Milord, the dishonesty and fraudulently, these are again two words, which is required to be bolded. The reference of this two words, Milord, is defined in IPC under section 24. Prove everything, they have to go to the root of the matter. Prove ingredients against me. There must be some evidence, or they have to go to the root of the definition. Now, section 24 is definition of dishonesty. Whoever does anything with an intention of causing wrongful gain, these all words are very important, or one person or wrongful loss to another person is said to the thing dishonest. This is the definition of dishonesty. Section 25, fraudulently. A person is said to be a thing fraudulent if he does that with intent to defraud, but not otherwise. My submission to this honorable court is that, Lord, just to prove 460, just to implicate me under 468, there must be the satisfaction of forgery for the purpose of cheating. Forgery as defined in section 463, that I am making a false document. False document which is defined under section 464, that, Lord, I may receive dishonestly or fraudulently I have did, and just to achieve wrongful gain and wrongful loss to another person. And the word which is used, the word which is used, but not otherwise. Just with a true intention, if I am doing just to achieve wrongful gain or just to make wrongful loss, on what, Lord, I have a question to myself, that is on the property. This is the definition which is to achieve my gain. Now, Lord, just to, I would like to take my Lord on section 23, which is, Lord, I have already read. Now, Lord, the here before my Lord is that, Lord, that allegation that I have got the document, that is, Lord, those three text messages for that day and walk. Now, Lord, I put a question to myself that I was officer, that is undisputed. My duty was that is also undisputed. My sending two messages about the situation of the report is my duty. Now, Lord, I put a question to myself that sending those two messages about the situation of the report, Lord, what is going on over there, that messages contains nothing. The fact that those two messages produced by them. Now, Lord, whether those two messages amounts to that, Lord, that I have sent those two messages before 20 years ago to achieve wrongful gain or to cause wrongful loss to other, except that nothing can be done. This is the IPCC. So whatever in my humble submission, those messages are correct or wrong. That is the subject matter of trial. Do it beyond reasonable doubt, but prima facie, except those two messages, there is no allegation against the public party. So that is why in my humble submission, Lord, this ingredients of forgery 468 are completely missing. So far as 471 is concerned, that also I can explain so long, but I will not take much time as it is available on this. I'll buy the punishment would be around 3 years. Suppose it's 471, but I will not make any. How about section 194, which is imposed against, which is implicated against 194? I may read out the definition: giving or fabricating false evidence with intent to procure conviction of capital offence. Whoever gives a fabricated false evidence intending thereby to cause or knowingly to be likely that he will thereby cause any person to be convicted of an offence which is capital punishment being enforced shall be punished with imprisonment for life or not. The definition says that giving of fabricating and false evidence with intent to procure conviction of capital. Now, undisputed fact is that whatever evidence I have given, that I have given before the Nana, not before any other. Saying that I have given a false evidence, let it be assumed before false evidence. Then also the Lord, Nanavati and Mehta Commission, as God was enacted into the Commission and Inquiry, does not have any punitive power, Lord. He cannot impose punishment to anyone, either capital nor for a single day. Commission, Lord, in my humble submission, does not have any right to punish someone. They can investigate, they can inquire, but they cannot punish. If they cannot punish the Lord, then the evidence which I have given before them at the capacity of an officer would not amount to the ingredients of this section 190. Suppose I have proposed the same thing before the trial court, then it would amount because the trial court has a right to punitive powers. They can punish someone. But before it all goes against me, final closure report was submitted and I been saved. So there is no case which is projected against me by the investigation agency that I have given a false evidence before the consent court. So in my humble submission to the 194, the ingredients are not missing. Because so far as evidence is concerned, from the section 5 of the Commission and Inquiry, I admit that it amounts to a civil court. Whatever the orally or written, if I submit orally, that is considered as an oral evidence. I will produce a document that is considered as a documentary. But the Nanavati and Mehta Commission cannot. Now, my humble submission to this honorable court is that this evidence was given before the commission. Now, if my lord may kindly see, my lord, there is a act, commission and lord inquiry act. Then my lord may kindly turn to the section 5. Lord, I will read from the section 5, Lord, the power of commission. And what may move from section 5, subsection 4. Any commission shall be deemed to be a civil code. When any offence is civil code, when any offence is described in section 175, 178, 179, 182 of the IPC, is committed in the view of the presence of the commission may, after recording the fact constituting the offence and the statement of the accused as provided in the code of criminal procedure, forwarded the case to a magistrate having the jurisdiction, try the same. The magistrate to whom any such case is forwarded shall be free to hear the complaint against the accused as if the case has been forwarded to him under 482 of the criminal. This is the section 5 subsection 2, now we got the subsection 5, subsection 5. I'm sorry, section 5, subsection 5. Any proceedings before the commission shall be deemed to be a judicial proceedings within the meaning of 193 and 228 of Indian Code. But if I have said something wrong, I have furnished a false evidence or false document under the civil code, the commission under the power of civil code had a jurisdiction law to initiate the proceedings against you for the perfect 314 or 3. They have not done it. So now, that chance goes. Now, be another the submission to the Supreme Court. This is I have read about the IPC 194, which is protected. Now, section 218. Here, my discharge application is there. I have taken a specific thing that in absence of prior sanction of the government, the court cannot take the cognizance. Now, in their own provisions of law which is invoked against me, they are admitting that I am a public servant. My burden of proof has already been shown. The 218 says, public servant training incorrect record or writing with intent to save person from punishment or property or 218 is there or not? That means whatever I have done, that was done under official capacity. If I am doing something in official capacity which amounts to an offense, our section, what? And the court cannot take the cognizance of law. Now they are admitting that the message which I have sent, that I have sent in the official capacity. Because public servant will not God is so that also will not this section will paddle because they have not obtained any prior sanction to initiate prosecution of this. Now 120B. 120B is concerned about the averment of FIR says that I co-accused Ms. Krishna, another co-accused P.R.P. Kumar, and one Zakia Dabri, who is not an accused in this FIR. We all have hatched the conspiracy to achieve a motive or to humiliate or to implicate some public officials or workers of some political party so that we not get a charge with the capital punishment. That is the nutshell allegation. Now, I put the question to myself that to hatch the conspiracy, there must be some premeditation of mine. Here, by admitting the case of prosecution as it is, the entire proceedings were initiated in the name of Zakia Dabri. She has not been done anything. With the help of one of the co-accused she was running an NGO, where I have first submitted, I have supplied the copy of status of the Supreme Court case where she was a petitioner. Here, my lord, surprisingly, this Zakia Dabri is the person who raised allegation against me in the complaint dated March of the year. Lord, if I am in a connivance with her or I had the conspiracy, there can be no possibility that she raises allegation against me. She has raised the allegation against me that I have not performed my duty well. I did not help. Along with all the list of accused, fortunately, I have not been joined as an accused, but allegation is there. So my submission to this honorable court is that when the base of this FIR is the complaint which is filed on 8/6/2000 by the Zakia Dabri, in that complaint, if I was in a conspiracy, that there is no possibility to raise allegation against Mr. Bhatt. He must have stated that he helped me. In case of that allegation against me, the theory of conspiracy is false. The second aspect is concerned by relying this FIR as
which is that complaint dated?
the complaint dated this is the parcel of the charge. That complaint is also parcel of the age complaint which reached to the Supreme Court and at the end of the that litigation this FIR. So in that complaint there was allegation against. I may read without only the relevant portion. It is on page number. My lord will note the page number 2620.
Okay, you can.
Allegation number 10.
Yeah, I have noted your point.
The allegation is that my lord. The allegation is that I have not performed my.
So by relying upon this, you want to say that
I was not.
if I was in a conspiracy, then he would have not made any allegation against you.
That is what my.
Yes.
Now, my lord may kindly fire. The allegation form of conspiracy is raised. As the rate was not the allegation that the one who accused was appointed as lawyer for Jakia's army. Another allegation is that the who accused was drafted a petition and the reply affidavit for Jakia's army. Another allegation made is that they have compelled her to file the complaint. Another allegation which has been placed against as a part of conspiracy that they have supported it. The word tutor has been, they become that tutor. They have provided tuition to Jakia Zafu how to depose before. Now, admitting all as it is, there is no allegation that I was played a single role in this all chapter. These all allegations are against accused number 1, the Shetal one, accused number 2, Shiara. Have any FIR specific allegations set up, not against. Not against President Donald. Their own case, admitting as it is, not raising any doubt, also will not form in the form that will not that the conspiracy which is held by both of them, not by them. There is no allegation. But my lord may kindly go to the affidavit which is filed by the investigation agents for opposing my bail application. Where also the Lord, तपासनी अधिया विकल्प कॉलम नंबर 16. और सर हमारा आरोपी नंबर 1 मिस रिश्ता सेटल हुआ और आरोपी नंबर 2 that is आरबीसी.
Yes.
तपासनी अधिया हकीकत हो सने नेजा बीना वर्षमा 27 फेब्रुआरी स्वयं को बोलता I am not this. आरोपी नंबर 1 नाय not 3 अरसामा गुजरात ना स्वयं को that is allegation. I may skip it not so that time can be saved. Allegation number 3, आरोपी नंबर 1 तथा आरोपी नंबर 2, that is also there also I am not there below. आरोपी नंबर 4, आरोपी नंबर 1 नायक आवतरणा बाबू पे citizen for justice. She was running that NGO. I was not a part of that. Now, all the crux of the allegations are there. 5, national human rights, that is also not a 6. That is not that petition have been filed before the High Court or before the Supreme Court. That is also again case number 1 and 2. 7. Nawatrana Prasute Aropi number 2. That is Mr. Sri Kumar. That is also against him. 8. Aropi number 8. आरोपी नंबर 2 ना होने तेरना सेवाकीय चालता कोर्ट काममा वकीलो पाड़ी मदद पूरा पाड़ी मदद करे. That is also against section number 1 and 2. Now this is the allegation for next. Farajgar आरोपी number 3, that is me, from allegation number 9 about the meeting. Whether I was present or not, I have given a false evidence that I was present. Text message that I have already demonstrated how it has been raised. Then the next allegation 10 as a part of conspiracy, same that the statement made by the Chief Minister, I was not there and I have given this statement regarding my actions. Now allegation number 11, that is the new allegation which is not raised in a charge sheet, but still it is not in a FIR also. Now, my lord, this is the allegation that my lord, in support of my plea that I was present, my driver has filed it, my ex-driver, Mr. Pan. So, my lord, he has also supported my claim that I was present. Then after, my lord, he turned hostile by any means. So he said that no, this affidavit was filed because Mr. Bhatt has compelled me to file this. So I have to file this. So, my lord, for that, a separate offense is registered against me. For that offense, my lord, again, in my humble submission, I should not be prosecuted. They have registered the offense. I was arrested in that offense. The case, Sessions case is pending before the consent court in Ahmedabad rural. I will provide the details. That is the case number which is FIR registered before the Ghatrodia police station by 149/2011. In 2011, when we have filed the affidavit, he said that you compelled me to file affidavit. That is why the offense under 189, 193, 194, 195, 341, 342, 465, 475, 122 was filed against me. The case number, my lord, it is 181 of 2018. It is pending before the Mirzapur court. So this is not the new allegation, my lord, which is raised against me. Now the next, my lord, પોતાને સ્વયં બંગલે મીટિંગમાં હાજર that I have not explained. રાજ્ય સેવક હોવા છતાં that also I have explained. Here, my lord, they are riding on two different horses. Now, my lord, કાવતરા દરમિયાન email સાથે that also I have explained, not provided complete email. આગળ દબાવવાના હેતુથી email થકી વિરોધ પક્ષના નેતા that also I have explained, lord, that it is not produced. So far as that packet of cover and monetary gain, no, nothing has been recovered. કાવતરા દરમિયાન સંચાલકો અન્ય વ્યક્તિઓને ઈમેલ દ્વારા સંપર્કમાં રહી સ્વયં દાહોદરાના ભાગરૂપે સુપ્રીમ કોર્ટ દ્વારા નિમવામાં આવેલ ખાસ તપાસ ટીમ અગિયાર મિલોટ the amicus curiae called me. I went there to give us my version, and that is why this is the allegation, Lord, that they have. Otherwise, it is observed in a judgment also, Lord. At the Gandhinagar mess, I went there to give my version to the amicus curiae. The Honorable Apex Court has directed amicus curiae that they are free to call any of witnesses, even the police officers, to record the same. Now, Lord, આરોપી નંબર 3 2002 ના બનાવમાં બનેલ નાયબ કમિશનરના આઈપી ની રૂએ રાજ્ય સેવક તરીકે ફરજ બજાવતા હોય નો પ્રાયર સેન્શન લોડ has been taken under 187. Now, Lord, the antecedent list of my antecedents are given. As per my instruction, excuse number 1, she was also having an antecedents law. He has already been considered by the judge. My antecedents list of antecedents are given. I cannot escape law. I am facing 5 prosecution at present situation. Where, Lord, first of antecedent on page number 13, that is the FIR. It is the same the allegation raised here that Mr. Pant has filed complaint against me. FIR against me, it was registered. The second is, Lord, regarding the Jodhpur, that is a different case. The third one is connection with the same event, it is registered in Palanpur. For the same event, Lord, 2 different cases are registered, but I cannot justify here. The one is that, Lord, custodial death. That there, Lord, I tell this a bit. I'm convicted at present situation, and my conviction appeal is going on. And the last one is, Lord, that 65, 66. I am in a custody since last 5 years, but till today they have not arrested me. I don't know why. Now, last submission of this affidavit is that, Lord, even everyone knows. First informant, defense, investigation officer, and the person who has drafted this affidavit, that this is the case where, Lord, if the conspiracy or modus or, Lord, that intention of doing this crime is made out, that is made out against only one accused who represent herself also, Lord, before the Supreme Court and High Court. So they are even investigation agency identifying this case not as a case of Sanjeev, but as a case of Tishta. I mean, my lord, may kindly see that signature of investigation officer. એમાં સર નીચે એમણે બ્રેકેટમાં એવું લખ્યું છે કયો કેસ તો કે ભાઈ પિસ્તા સેટરવાળની જનતા. So I was joined as accused number 1. So this is number I'm just trying to demonstrate that this is the hard reality. Absolutely lighter too. My lord, at the last end, now I would like to give my closing argument. So, as I have submitted a lot before this honorable court, my closing argument, Lord, my first argument is that first informant has completely wrongly interpreted the word which is used by the Honorable Apex Court in the judgment. The Apex Court has said in paragraph number 88 to deal in accordance with the law. That the Apex Court could have said that, Lord, that the concerned police station must have registered the FIR against the Apex Court has not said that. The Apex Court has said that even has given a false evidence to humiliate or to harm the reputation of any person, they should be dealt in accordance with law. Now, Lord, here in my humble submission, accordance with law means that where I have given a false position or false evidence that we assume as it is for sake of argument, that is Nanavati and Mehta Commission, 340, 195 to prepare, no error. Second, Lord, SIT, they can give the complaint before the consent court that I have produced a false evidence, no error. The third one is the court will not consent who has accepted the closure before not raised any grievance against me that I have given a false evidence, not registered any FIR, or not registered any proceedings under 340 and 19. So this is my humble submission that accordance with law, that this three authority would be not entitled to initiate proceedings against me in accordance with, not the police. Now, my lord, the second, the root of the FIR is that, my lord, that the complaint which is filed by Judges applicated acts of nature and other proceedings where, my lord, I was not a party in Supreme Court. I was not a party of any of them. Rather to say that, my lord, that complainant has, I am the person against whom this complainant Judges has raised here. Lord, I not at all cannot be joined as a conspirator, my lord, of Judges. And she has not been joined as an accused. So another allegation is that, Lord, that I have been joined in this FIR is that, Lord, I have sent two text messages with those two messages are what they are saying. That is the issue as it is that those two messages were sent on the 27th February 2002 and 28th February 2000. After 20 years, suddenly they have realized that those text messages are wrong. And fourth one, and that is why, Lord, we are registering FIR. So, Lord, those messages were sent in an official duty. They could have registered the FIR before 20 years, but they failed. Now, Lord, now they are saying that I have produced these two messages as a false evidence before the Nanavati and Mehta Commission. Then too, it is happened, Lord, in 2000. This 2000. Then also, Lord, they are almost more than 11 years late to register the FIR. Now, Lord, neither Special Investigation Team, nor Nanavati and Mehta Commission, nor Court number 11 filed any complaint against me. Furthermore, the Court number 11 has accepted the report. There is no ingredients, as I have explained, there is no ingredients of 468 and 194 I am not submitting here. Remaining are not available. So, Lord, in absence of ingredients, the FIR is registered against me. The broadly allegation against me is that to help Dakia's Apni, but these are the same allegations raised against the co-accused Lord, who has already been enlarged on the bail. Now, Lord, I would like to take my Lord on the order I have annexed, the accused number 1, where the Honorable Apex Court, she has been enlarged by the Honorable Apex Court after what happened law. Honorable Apex Court has observed, Lord, in this judgment in paragraph number 36, if my Lord may note this only, I will not read entire judgment. Taking what is the consideration, Lord, the Honorable Apex Court has taken into consideration is that the most of evidence in present case are documentary evidence, which are already in the possession of investigation. Further, the charge sheet has been filed, and we find that she is entitled for paragraph number 36. Here also, all documents are under possession of investigation agency. All the allegations are in form of documentary evidence. Now the investigation over and charge sheet is concerned. I may request for the clarity. Now, Lord, on the basis of this order passed by the Honorable Supreme Court, our Honorable High Court has also enlarged to accused number 2, who is the person who helped who has provided tuition to Jacques Apni. Where, Lord, the Honorable High Court, I have annexed the order, Lord. I will not take much time. But paragraph number 6 is relevant. That this court is also considered that the entire case is based on the same which is observed by the Honorable Apex Court is observed by the Honorable Apex. Now, Lord, two aspects I am anticipating that my learned friend may argue against me that, Lord, that the first accused who has been enlarged on a bail was a lady accused, but that is not the sole ground. If it is a sole ground, then, Lord, I cannot say. Even, Lord, Justice Kaju in once in his lecture, he said that law cannot be a gender bias. And not everyone is equal. There is a claim of equality. That must be. At the time of committing offense, there is equality. Then at the time of releasing them, there must be equality.
We will go by law, not by the words.
That is what I am saying. But even my submission is that law cannot be a gender bias. So we not maybe a one of.
So far as lady accused is concerned, there is a specific provision which requires consideration.
But here we not. If it is only under that provision it was granted, then I cannot say anything.
And if that were the words, it should have been written in the judgments, not in a lecture.
I cannot.
So
my submission is that
yes,
if there is a sole consideration that she is a lady of truth and that, then I don't have a case. But here the Honorable Supreme Court in paragraph number 36 observed that it is a case of documentary evidence. It is in the possession of your investigation. There is some observation in R.B. Sri Kumar also brought. He is aged about 75.
with no antecedent.
Also having a health issue. But along with that, the Honorable High Court has observed that the entire case is based on a document. I only put a question to myself that not that the lady accused and not this health issue. This
Yeah.
two
I
grounds.
will take your argument. Ke first consideration was that it is a documentary evidence and charge sheet is filed.
I'm grateful.
These were the other factors were the supportive consideration.
I'm grateful. There are not many judgments on parity, but I may only apply one law, that is the judgment of justice. Case of Lord Ramesh.
Go to by Dhabi,
Yes.
2011.
This is about the parity. The second one, I am also anticipating that they will say that I am having antecedent. So it's light of antecedents. They parity.
So you can point out their judgment also.
Prabhakar Tiwari, MS apply to the
Court should consider the merit of the case. And
I am grateful to my Lord for the providing patient will hear. Deeply aware.
you told me that PP is going to argue.
Now he became.
I know, earlier my submission.
Okay. So
Possible possible. And the second sitting, one matter is the appeal is going on before division bench. Of same ethics.
maybe not possible
So
up to then it would go after 18.
after 18,
Either I can keep it tomorrow,
so 18 or 19.
19th we can have it. Because I won't be available from 15th. So 19th or I can have it tomorrow.
I'm happy to. Even I will be enlightened then also.
Then also. So no, we are not.
That is why I'm honestly saying that I am not going to be prejudiced by Excel. No, I don't have an objection.
Therefore, you came after a long time.
That was I have advised to my client, I don't know. 19 no issue.
Both convenient which date? You can tell.
I cannot say my presence to be distant. My colleague will be.
So you have completed all your arguments, including our anticipation what he is going to submit.
What I believe that may be this. If
So-
something may be happened, then I will on the same day.
Same day.
Give my report.
So
I will
no
not ask.
counter.
No, I will not let him do this. I can understand that there is a limited parameters at the time of this. My lord is the man enough to go into such a.
So sitting maybe
ચાન્સ ફિક્સ જો ઇન કેસ આપ ફરી નહીં ગયા
નહીં જ થાય કારણ કે પુરાવો હશે ને એટલે એટલા માટે આખી કોર્ટ બેઠી રહી છે
આ તો પણ સર
એટલે સેકન્ડ સિટિંગ રાખો બાય ધેટ ટાઈમ
ચોક્કસ
મોર્નિંગ હાઈકોર્ટ યુ કેન ગેટ તમારી ત્યાં જ ચાલુ છે
હા
ઇવન 19th માં 19th ના
સર આ
That I am not okay.
આ એકદમ પૂરી થવાની પોસિબિલિટી છે પરંતુ કદાચ ના થાય તો તો ઇન કેસ એવું હશે તો
સેકન્ડ જ રાખો તમે જોઈ લેજો ઇફ કન્વીનિયન્ટ હશે તો સવારે લઈશું અધરવાઇઝ